somebody who designed you. For example, God making all of us, gave us unique features, makes our designs unique. And that is why we have products in society like the air conditions, the cars, the aeroplanes, the televisions, and the fridges, and everything in our homes have got an outside appearance which is registered under patent, under designs. And so under industrial property, design is one of the parts which also we can seek protection over it. If you have any idea of how to design a mobile phone with a specific unique feature, that outside appearance, you are protected. That is why you cannot get up to create a car and pick up the design of another company and make it your own. And so we should always be mindful about that. It also borders in music. It doesn't come in music precisely as the music notation or the rhythm or the harmony. But then the event you host and the designs you do, if somebody also picks those kind of designs as per your own creativity for your music event, you can still fight over it if you have registered the event designs within it. And then we have trademark. Trademark comes in 3 different forms. We have a name which becomes a trade name. For example, Bnoskka. The name Bnoskka is my trade name. And so therefore I use it to trade. I use it to do programs. I use it to do events. And then I've designed it as a logo as well. And that logo also becomes a mark. And so if I create a TV and call it Bnoskka TV, or if I create a television and I call it Bnoskka Television, then that logo on that television will be a trademark where people will see it and believe that, yes, indeed, it's a trademark which is coming from Bnoskka. And so therefore, if anybody also makes another simple object or any other thing, be it a cloth or any product, and you put the name Bnoskka on it, you would also be fined infringing on that trademark. For example, Adom TV, their microphone here and their label on it is a design and which is form part of intellectual property. Then we also do have what we call name, which I've already said, name. And then we have images, which can be either a logo or any symbol which can identify. For example, Uprise Music symbol, which is my partner in this public lecture. The symbol behind us also is a trademark. And so the logo within it, you cannot pick it and use it for any other thing without authorization from the company. And so if I don't have the authorization, they wouldn't be able to display their logos here because I would be infringing on their rights by using their trademark to sell my product. In other words, telling people that, oh, Bnoskka's production is very good. That is why Uprise Music logo can be found in it, or Adom TV can be found in it, or Onia TV can be found. And even as we're talking, Asempa FM also picking it live, their logo being here also signifies that they also are agreeing and I am not infringing on their right because it's an agreement which we've had. And so that is intellectual property under the industrial property. Then we come to copyright, where copyright also here looks at the expressive qualities of any image or anything we create, be it a film, be it music, be it clothes that we are wearing, fashion designers, even computer games, animations, textiles and fashion, leather work, even folkloric materials, all fall under copyright. And that is why copyright, therefore, here protects the artistic creativity of people who use their brains to create songs or film or anything which is of artistic expression. So if you do a leather work, you make a shoe. The shoe, outside appearance of the shoe, which is the design, is under design. Then a name which you put on the shoe becomes a trademark. And then how you have been able to make the shoe as one complete, you can patent it. And then if you make a song about your shoe, it falls under copyright. And that is how I want us to understand. And so therefore, let's look at how does copyright protect music. Copyright gives us protection in music in 3 different forms. We have what we call the creation of the music, which is create. If you want to create a music and you want to make sure that you are protected, you have to make sure that your songs that you are creating is your original work. And original here means that you want to create in the genre of Ghanaian high life, either palm wine or osode or adowa or any of the Ghanaian traditional music that we know in Ghana. That creativity that you are going to create can be in a form of words, can be in a form of melody, vocal melody, or can be in a form of musical notation, either by staff notation or tonic notation. And this kind of notation, you are also protected under law. And how does the creation becomes original? It becomes original when everything in it, the melody, the lyrics, the text, the harmonies involved, are your own creativity from your head that you have created. And I must say that intellectual property is a property just like our house, our car, our fridges, everything that we have that we hold it dear, including land. So that intellectual property, because we cannot hold it, and so therefore people think that somebody else should protect it for you. No, it is your own personal right. So if you have the imagination, if you have the knowledge to create it, then you are the rightful owner to be able to protect that work. We will come under the protection. But let's look at the creation. Now, people think that I want to create a work. And that creation, that work I'm going to create, I think I want to create it to look like something. Somebody has created a song and I like it. Then you go and pick a part of it. That is what we call sampling. And sampling comes into 3 different forms. You can sample by copying the work directly and then placing it in your original work. It is against the law. Or you can pick what we call interpolation. Interpolation here in music means that the person plays the bass guitar and you pick the bass guitar pattern he played and put it into organ or put it into voice or even arrange it for a different musical instrument within your work. And when that person hears it, for example, the Yaponsa sound that we all know, that you can pick the Yaponsa sound and then put it into an organ. Organ will play it. If it is against the person's wish and he sues you in court, you will be found wanting because you have interpolated his work, which is interpolation. Then you can also do what we call copying sample. Copying sample here means that you have picked the work word for word or melody for melody or rhythm for rhythm or beat for beat and then drop into your work completely without any changes. Copying, sampling. And when you do, you might be thinking that, oh, I like Kwame Eugene, I like Shatawale, I like Stoneboy, I like Fameye, I like Kofi Kenata. And so what I'm doing, I am promoting them by copying their work into my own work. It is unfortunately not so. Nobody wants you to promote anybody. If you want to create your original works, make sure you are not copying anybody, either by interpolation, either by simply copying. The next part of the sampling, which people also think that it's not against the law, is what we call rework copying or rework sampling. Rework sampling here means that you have picked a particular song and then the person did the song in reggae and you change the work completely and turn it into a high life. And we all know that reggae beat is different from high life beat. And so you have reworked the whole work, but you have sampled. You are not allowed by law to do that. Because the moment you want to pick somebody's work, you need permission from them. And so that is the part of creation. You cannot create your work and be using other people's material when you do not have a right over them. Now let's look at how do you protect your work. The law gives us 3 forms of protection. The law wants to protect you so that when you have created your work, people will respect your work and be able to make sure that they also help you to get food or to get economic benefit. And so these 3 forms of protection, the first one is what we call moral right. Moral right here means that your name must be called on your work anytime, anywhere in the world. Anytime somebody calls the song or the work and they mention another person's name, you can sue the person in court. And even if you die 1,000 years and your children or your great-grandchildren are there and somebody sings that particular song and they attribute it to another person's name, your great-grandchildren can go to court and that person will be found wanting. And so we should understand that moral right does not expire. It exists in law. We call it perpetuity, meaning forever and ever until the whole world ends and we all here are no more. forever and ever, intellectual property, the moral right of your name being associated. Now let's look at what are some of the benefits or characteristics on moral right. Moral right gives you the permission or the authority to be able to prevent people from using your work in a way that will tarnish your name or your image. For example, I've made my song, and then you come and tell me, Bnoskka, I want to use your song for a beer advert, and I don't like beer. And I didn't give you my permission, and you go ahead to use it. I cannot sue you for infringement. I will sue you for my moral right's sake, because you are tarnishing my image. I am maybe a bishop or maybe a Muslim, and I don't drink alcohol. So why are you using my song in my name to promote your product? Even if it has fallen free, I have no economic right over it. Once my name sake, you want to tarnish my image, I can go to court, or even my great-grandchildren can go to court and say that our father never liked beer, or he never liked pito, or he never liked alcohol, or he never liked any advert about football, or anything about lottery or betting. And so please, don't use his works in that because of his namesake. That is moral right. Establishing the fact that you, morally, whatever you believe in is associated to your work. And if your work is being used in something that you don't believe in, per your moral right's sake, you can go to court and the court will listen to you. If you go to court, what are you going to do? You are going to quote the Ghanaian Copyright Act, which is Act 690 aspect. Another aspect is that for the name of yourself that exists forever, if anybody picks your work, even with your permission, and then they change your work with your permission, but they fail to mention your name, that the original author is Bnoskka or Apostle Efriye or Aduma Super, and then they rather put their name, I'm the arranger, Derek Money, everywhere. So Derek Money has arranged this song, but who is the original author? He fails to mention. Once that aspect comes in, you can go to court and sue the person who did that work, and your moral right was not acknowledged. Even though the person, you might have charged the person money. You have given the person the right to use your work in any form. You have collected your money, but they failed to mention your name. And because they failed to mention your name, moral right says that you can sue the person to make sure that they fix your name in the work. Because you cannot rework on somebody's work and claim as your own original work. That is what the law says. So this is the protection of how the Copyright Act protects you in terms of reworking, sampling, or your name being associated with it. The last part of the naming aspect is this. Even if you decide that tomorrow all the songs I've created, I don't want to get any money from it, it is free for everybody to use. Anybody who uses it, plays it on radio, plays it on TV, and mentions somebody's name apart from you, the person is also still infringing on your right. So moral right exists in this form, that your name must be associated with it forever and ever. Your name and the things you believe in should also be protected by your work. And even if you grant somebody licenses to use your work, to change it, to do any form, and then the person fails to mention your name, moral right's sake, you can go to court and then that aspect will be corrected, or the law court will listen to you because that is your moral right. So that is one protection. Now let's go to the second protection, which we call economic right. Economic right here simply means that money, cash, get there, ega, as in the ever saying it, or sika, kudi, by the Hausa, right? Right. So, as long as you are alive, by Copyright Act, if you create a song, or you write a song, or you sing a song, and it is for you, it's your own personal song you have made, as long as you are alive, I, Bnoskka, I'm telling you, you must get every money that will come out of that song. Whether it is played at wedding, party, funeral, or somebody is happy, is jubilating at the beach, or radio, or television, or even at this public lecture here, if I play your song and you do not get money, then your economic right is being infringed. Now let's look at the varieties of economic rights and how can musicians take benefit in it. Economic right here first exists in one, to be able to make sure that you give people what we call license. License here means that you have to eat from your work, but you cannot be working in town and be chasing Grace using your work for her wedding, or be chasing Apostle Efriye using your song in his church, or be chasing Londona playing your song on radio. And so because of you can't be able to do that, the law says that let's establish what we call a collective management organization. And that collective management organization, some people call it Collective Management Society, CMS. In Ghana, we call it CMO, Collective Management Organization. And so, by law, the only company which has been established in Ghana here, or all over the world, to be able to collect royalties is this CMO or CMS, Collective Management Society or Collective Management Organization. It is just a use of words. Some country decides to call it a society, some decides to call it organization. Before 2005, the Copyright Act, which was the 1985, the PNDC Law 110, which protected copyright, we were calling our own Copyright Society of Ghana. That was the collective management society responsible for what? Making sure that when songs are placed in public domain, from funeral, wedding, party, church, stadium, radio, television, in any public space, that was the organization responsible for collecting money for the musician under the economic right. Now, the third part of the economic right is this: anywhere your songs are played, anywhere in the world, anywhere on earth, apart from the fact that your works is being used for education. Education here means, for example, if you Bnoskka, I teach at the University of Education, Winneba, and then I use your song in my classroom to be able to teach my students about harmony. That in this song, the first harmony or the first chord in it is chord 1. And then the author moved into chord 2. And then he used chord 3 here, came back to chord 1, and finished at chord 5, imperfect cadence. If I do that by law, I have every right to do that because it is under education and it is free. So you, the author, cannot come and ask me for money. So any university, any secondary school, any primary school, any KG, they can sing your song in the school for the school children to be dancing, to be playing, to be singing in numbers. Ripe, ripe, ripe fruit. Have you any way? I don't even know how to sing it. They will sing it 1,000 times. You cannot go and collect any money from them because it is under education. The law says free. But there's a caveat here. If that primary school, that KG, that's JSS, junior secondary school, or senior secondary school, or that university, or that institution, decide to say that, okay, today we want to do entertainment. And every student, because you are going to run spinners, you are going to hire spinners, or we are going to use bigger speakers, and you are coming to dance, we are going to do entertainment, and you must all pay 1 cedi. The moment money, 1 cedi, or even the children, the KG people are paying 50 pesos, for that song to be played, you have to pay royalties. I want to repeat it again. To the right owner, the one who has created his song, a KG who decides to do our day, and they say students should pay 1 cedi for entertainment, or JSS, we are going to do entertainment and pay money. The moment pay money comes in, any song they play at that particular school, the author must get money. If the author doesn't get money, it means you are infringing on his right. Because under the Copyright Act, performance here comes in. And we are looking at protection, and then his right as what? Economic right. Economic here means any whatever that bothers about money which is not used for free, then it means that money should come to the one who created the song. Now let's look at another exception beyond education. Personal use. The law says personal use does not come under economics. For example, I've gone onto the internet and I've downloaded familiar song. Very soon, Open Gate or Asido Kinpaluta. Then I've downloaded it on my phone and then I'm playing it for personal use. I pay nothing to nobody. Or you pay nothing to nobody. You owe nobody no money payment. But the moment you want to use your phone as a party and invite people to come to your home, it has moved from personal use. Now you have ventured into what we call public performance. So the issue of exceptions and the economic right, if you are using it alone, Apostle and his wife and his children, they are at home and they are playing their song and they are dancing, there's no economic right in. It is their personal use. But the moment he invites friends, oh, Uncle Ebo, please come. Londona, come. Chairman, please come. Oh, you. The moment people congregate in your house, you have moved from personal use, because you are going to play a song which is loud enough for everybody to hear. And so therefore the law comes in there. We'll look at how to deal with that one later. But now, let's look at the economic right. And so, the last exception is that as long as you are playing that song on your phone with headphones and a friend takes it and listen, it is no commercial. You are free to do that and you are free to use it anyway, anyhow. But if you and your friend wants to do listening party and be playing song from somebody's phone, that phone which is personal use has now fallen under public use. And so the law says that you must pay right. Now, the reason why some of these things goes on in our society, even here in Ghana and so many parts of the world, and that we don't usually see people going to court over it, is that people think that they should do it for free. It is their intellectual property. For example, your car is your property. If your car missing, I have never heard anybody getting up and his car is not there, and then he say, oh, it's all right, if it is stolen, it's okay. You will surely go to police station, go and report, because it is my property. Or you buy land, especially here in Ghana. People have, one land has been sold to by 5 people, and they fight and fight and fight and fight. So one person said, it's okay, you won't fight again. Pick it. And then that's it. It's the same way with your song. As a musician, if somebody uses your song in any means, and it is making money out of it, and that money is not coming to your pocket, economic right says that you are being infringed on your right. You are being infringed. So that is economic right. Now, the third protection under music is what we call protection against unfair competition. Now, I'm a musician. You're also a musician. He's also a musician. And then we are all creating music. And then I go to programs. I don't sing your songs because I don't sing my song because my song is not popular. And then I sing your song. And then I tell the audience, oh, you see this song I sang? My own songs are even better than this one. Please go on YouTube, go on TikTok, go on here and go and stream my songs. They are better than the songs I sang here. The moment you say those words, you are infringing on the person's right. And in Ghana, this particular act, which we call Protection Against Unfair Competition, it is not in the Copyright Act, but it's a complete new law which has been passed in 2003. It is called Act 589. And we must be able to understand that even as a musician, this protection affords you. And so don't lose sight. Now, even beyond that, the protection, You see people who are walking on the street. They have dressed like Sarkodie. They've dressed like Shatawale. They've dressed like Kwame Eugene. They dressed like Medica. Dressed like, what do you call it? Mr. Drew. And then they are saying, oh, I like my fan is Kwame Eugene. And so you pick Kwame Eugene songs and you are singing. To the extent that even people are inviting you, oh, Kwame Eugene look alike. Come and sing Kwame Eugene songs at my party. Protection against unfair competition is the law which can be used to fight against you. Section 1 says, causing confusion in the minds of the people. Are you Kwame Eugene or not? Why can't we invite Kwame Eugene, but invite look-alike? So protection in music here against unfair competition here means that you are competing with the original artist and you are making money from him, of which he is at home. He's not getting shows to play. And it happens a lot. These days you see them dressed, they even try to dress like them. And they try to make their hair look exactly like Mr. Drew or like Medica, Kwame Eugene. And then you go about, oh, I'm Kwame Eugene look alike, or I'm Medica look alike, or I'm Manifest look alike, and you are singing his songs and you are dancing like Mr. Drew. Please, protection against unfair competition can be used against you. Don't mislead the public. That is the section 2 of the protection against unfair competition. Misleading the public. You are trying to even make it look as if that it is Mr. Drew who is dancing. Meanwhile, it is not him. There's a current situation here in Ghana, which is already known in the radio, and I've decided to address it here at this public lecture, where an artist has been picked or has been spoken about. We want to use your image for our advert. And then he says no, or for some reasons they are not able to reach into agreement. And then they find somebody who looks like him. Like Bnoskka. They look somebody who looks like me, Bnoskka. And then they put you on advert. And they write the person's name. They will not write Bnoskka. But when you look at it, it's not Bnoskka who is here. It is also against the right artists. Especially when you are riding on their popularity. We call it misleading the public. Okay? Now, the law explains it in this way, that if the person is not Bnoskka, who is popular, who is known, would you have picked him and put it on your advert? No. And it also falls under trademark, because the person has made a name which has become a trade. People are using him for his works. People are endorsing, he is endorsing. He picks Uprise Music and say, oh, this is Bnoskka. I endorse Uprise Music. Go and do publishing with Uprise Music. Go and do distribution with them. And then everybody is now happy. Then you set up your own Kwesi publishing company. And then you go and use Bnoskka's picture or somebody who looks like him. And then you say, oh, I support Kwesi publishing. Please go and use it. Because you are looking like Bnoskka, you are trying to ride on his popularity. To do that, protection against unfair competition can be used against you. Because it's not under copyright, people think that it doesn't fall under music. It does. It does fall under music, so we must be mindful about it. That is under the economic right. Making sure that every money, every image, everything about you comes to you personally. Now, let's look at another part. Protection. If you're a musician and you become popular, your picture, even if it is used at a barbering shop, they went and printed it, they paid money. Did that money come to you? No. So as long as that money, which is on the barbering shop signboard, nobody paid you, it is infringing on your right. It is in the Copyright Act. It is infringing on your right. So if you have not authorized anybody to be using your picture for billboard or advert, saloon advert, or photographer, or barbering shop, or any billboard or any advert, and your picture on it, and you are not getting any money, my friend, I'm telling you, come and speak to me. I'll make sure that I'll find money for you. We will sue the company, at least not less than 500,000. Even if they bargain, at least half of the money, 250,000 is a lot of money. It will come into your pocket because it is your right. You might think that, oh, it is not music, it is just my picture. Is it not the music which you have made and now you have become popular? And imagine if you had not made music and you were not popular. Do you think they care about you? They don't care about you. They care about you because you have become popular. They care about you because you have become an important person. When they put your image on their barbering shop, people will see, oh, so this artist, Bnoskka, comes to barber his short hair here. Oh, Londoner comes to barber his hair here. Oh, Derek Money, the way he has. If you want to even dye your beard like Derek Money, come here, we'll do it. Because even his picture is here. When those things are going on, they are using it to get money. Because you have become somebody important. And if you don't speak against it, money will be passing you by and you'll be going hungry. So we should know protection for an artist, economic right. The last part of the protection and the economic right is that, unfortunately, it expires. Economic right does not last forever like the moral right. Now, under Copyright Act, specifically for music, the whole world, the international law which protects every musician, we call it the Berne Convention of 1886. This Berne Convention has been ratified, meaning Ghanaian Parliament has accepted it as the laws protecting Ghanaians and other foreigners living in Ghana and any part of the world, somewhere in the 1990s. And so, therefore, if your works are being used everywhere in the world, as long as you are alive, every money, every activity, you must authorize it. You must authorize every activity for the money to come into your pocket. If you have not authorized it, it means you have to sue anybody who is using. But unfortunately, the moment you die, the day you die, the day death will come for you, the day you breathe your last, then your children must be able to use that, your song, and take care of themselves. Pay their school fees, pay their rent, use it to even build a house for you in your name for 70 years before it falls under the category we call public domain. For music, it is specifically 70 years. Another time, I will talk about film in another public lecture. But for music, it is 70 years. And even that 70 years, even if you license somebody for the person to be using it, then the moment you die, they start calculating. So let's assume that Gold Coast made a song, and Gold Coast died in 1957, 6 March. And then Ghana was born. So all the songs that Gold Coast made, now it is how many years? 68. So 2 more years before Gold Coast songs can expire economic right. But his name, that is Gold Coast, the name being associated with the song Gold Coast made, can never cease. That one will exist forever. So let's assume that somebody was born in Gold Coast. Somebody like Akeku, somebody like Bob Cole, somebody like E.T. Mensah, somebody like E.K. Nyame, somebody like S.K. Yamwa, Nyasemhwe, the first album of Nyasemhwe, and all other musicians who made songs, they have died. And if you calculate the day they die, 70 years has not come. And so therefore, if you go on YouTube, people are streaming their songs there. If you go on TikTok, their songs are being streamed there. Where is the money going? Is it going to his children or his grandchildren? Because it is a property. He can even make a will and say that my child, Agwetu, or my child, Londona, should enjoy from this my song. That is my inheritance for him. Because it's a property. Just like your house, just like your cow. There is rules and regulation governing it. The rules and regulation governing it is that, you see, Ghana has a name. So Ghana has a moral right, right? Like I explained earlier. And under that moral right, if you use Ghana national anthem in any of your song in a way that brings disrepute to the name of Ghana, Ghana and the president, who is the the chief commanding officer of the whole country, the first gentleman of the land, or if it's a woman, the first lady of the first gentle lady. Oh, how do we say? Now, the first lady is the wife of the first president. The first lady. First lady. Okay, so the first gentleman. But here we have first lady being the wife of the president. You see? First lady. That's the wife of the president. You understand? Yeah, that's the vice one. So if a lady is a president, how do we address her? Her Excellency, right? So Her Excellency can say that whatever songs you have created, because it brings disrepute to Ghana, we prevent you from using that song in your work, even in your video. Or you see people, unfortunately, in court, they move naked and they are playing Ghana national anthem. In fact, police will arrest them. Police will be arrested because moral right, Ghana's name associated with that particular song or Ghana national anthem, must be protected with all dignity. And that is what public domains here means. So songs that are of public domain must still be protected in a way. Then the last part of this public domain under public what you call usages is what we call folklore. Folklore here means that they are songs of old times, not songs of old records. Please do not mix the two. Some people think that Kakeku songs are folk songs. Please, they are not. They are for Kakeku. Folklore songs are songs where nobody created it. No single person can be attributed to its creation. For example, when you go to the beach, the fishermen, they have some songs they sing to pull their net. If you ask them who made the song, they say, oh, this one there, we came to meet it too. And that is a folk song. Right? Yes. Danase. It's not a folk song. Somebody made it. I'm researching about it. Somebody created Danase, da onyame ase. There is a creator. Ase danka nyankopon yesu emeneo na maminsuro. It is not a folk song. There is a composer. And onyamka nyankopon, there's a composer. All those kind of tunes that we sing, aye re, they are composed by people who are alive. Some are dead, but still, they have not fallen under public domains. So these praise songs, Pentecostal praise songs, they are not folk songs. They are not public domain. So we should not look at them as such and say that they are public domain and therefore they are free. So we can use it anyway, anyhow. That is the three aspects of public domains. Now let's look at how do we make sure that we protect our interests in terms of music and how intellectual property plays in a way. Music affords you, it helps us to release emotional stress. Music helps us to make church. Music helps us to be in school. Music helps you when you are sad. Music helps you when you are happy. It helps you in so many ways. But let me ask you, the musician who has created this music, who has created this kind of songs, what must he also do? Don't you think that he also has a life to live? He needs to make sure that he must eat from the songs he created. He must be able to get economic benefit from it. So people misunderstand the property of music. If music is a property like a car, like a house, like a fridge or television, when you get up, or even mobile phone. These days, mobile phones are so important. I was walking on the roadside and I saw one lady protecting her phone and a car came to knock her. Very serious. And when she knocked down, when she got knocked down, she was rather looking for her phone. And blood was coming out of her face. Because her phone as a property is more important to her than her life. And that is how I want musicians also to see their songs as very important. Because that is what is bringing you food on your table. That is what will take you to hospital. That is what will take you to anywhere you want to go by means of transport. And so therefore, I want to declare by this public lecture that every musician who will have to be put on television for us to contribute money to that musician is a failed musician. Because your songs are being used in society. It is generating money. So I want to declare again that any musician whose picture will be put on TV, that he has gone broke and he is sick, we should pay money to that musician, is a failed musician. Yes. Why do I say failed musician? When your songs are trending on social media, that you should get money from it. When your songs are being played at funeral every now and then, every day, and then you tell me that you don't have money, and then your family people put you on TV, that you are broke, you don't have money to go to hospital, you can't even pay your rent, you can't even send your children to school, you can't even have money to buy food to eat. And so we, the people who are in Ghana, should be paying money to you. You are a failed musician. Why is it failed? Because music is a property, like your house, like your car, like your mobile phone, like your laptops, your televisions. And when you get up and it is stolen, will you just say, oh, it is stolen, it's okay? Who wakes up and realizes that his land, somebody has started building on it, and you say, oh, it's okay, you build, that's okay. And then when you become old, you now go to the person who has stolen your land, and you say, oh, I'm now broke, oh. Can you contribute money so that they take me to hospital? Can you contribute money so that I go and be put on dialysis? All those musicians, whoever came on television, unfortunately, they are failed musicians. I'm telling you. And I declare that any of you musicians here or who are in Ghana, you should never be put on television that you are broke. Because if your music is your property, you should protect it today. And by protection means that if your songs are being used for advert and money is not coming to you, sue them. If you can't go to court, go to legal aid. They can help you. Ghana Legal Aid, they work. If you can't go to Ghana Legal Aid, you can talk to Bnoskka. Yes. I'm telling you. And when you talk to Bnoskka, Bnoskka will also assist you to make sure that you get money. So let us try. Thank you so much. So to be able to run up on this, my public lecture, I want to say that Ghana and all the musical genres we have, all the wonderful artists we have, creating songs all over. Please, we should take music as our property, like our house, our mobile phones, our car, our children, and everything we have, that we hold it in dear and we protect it with our lives. We should protect our music with our lives so that we will not be failed musicians and our image will be put on television, that we don't have money to go to hospital, we don't have money to buy drugs, we don't have money to pay rent, we don't have money to buy food, we don't have money to even live, and we will never be failed musician. I want to end here and then ask for questions and answers so that we'll be able to close exactly on time. Please give the microphone to anybody who has a question.
If my music being played at a party, yes, or in someone's house, okay, how can I go there and collect my royalty? Or
Thank you. If your song is being played in somebody's house, even collective management organization cannot go and collect money for you, because it is now under personal use. Yeah. But if that house is doing funeral, and then they have mounted spinners
or party,
the spinner who is playing at the house must be registered. So if that spinner is not registered, then you don't go there. Just report to Gambro, where you are a member, that your songs are being played here and you're not getting any money from it. Then it must be sued to be able to get money. So I want to say that individual musicians should not attack people who are using their songs, but use your registered agency to get your money, or make sure you record evidence about it if you have not authorized any collective management organization, then unfortunately you can also not get royalties. But if you have registered and you're not getting the royalties, sue the collective management organization like Gambro. Sue them. All the people who are in town every time unfortunately insulting Gambro, that Gambro is corrupt, that Gambro does not pay fair copyright royalties. Please stop insulting them. Go to court. I am telling you, if we have 10 people suing Gambro in court, Gambro will do what is right. What is right here means that they will pay you itemized royalties. Itemized royalties is that they will show you your song was played on Adom FM, it was played on Adom TV, it was played on Top Radio, it was played on Top FM, it was played on Top TV, it was played on Onia FM, it was played on Onia TV, and therefore you had 120 minutes for the whole year. And 120 minutes, when we calculated, every minute is 10 cedis. So 10 cedis times 120 is 1,002. So that is your money. But then they don't do that. And they just tell you, oh, Max, your songs is 70 Ghana. Then they send it to you. Then you are angry. Yeah, then you pick snap. I remember very well, somewhere 2016, 2017, so 2015. One lady picked snap and X and went to Gambro office to go and curse them. And to not work. Please go to court. If you go to court, it will work. You see, we used to think that when mobile companies were playing songs as ringtones on their network, we used to think that it was free, it was okay. Until 4 people decided to take them to court and they won. And so now, therefore, they are paying money to anybody whose song is used as ringtone. You see? So until somebody suing Gambro, 20 people, 15 people suing Gambro, we might think that everything is okay. By the way, Gambro too, their license have been withdrawn. And yes, as of now, they don't have a license. So if you sue them, then they don't have money to collect. But anytime they pay you, then it means their license is back. Then you can sue them if you are not happy with what they give you. Yes. Any other question?
Hello?
Yes.
Hello.
Hi, there's money everywhere.
Yeah, my name is Eric Money Everywhere, as you mentioned. I want to ask, you made mention of CMOs, Collective Management Organization, and then the one I know is Gambro, and then ASOC. And then ASOC belongs to the movie industry or the film industry, and then Gambro belongs to the music industry. In your capacity, can you suggest to the government or the president any other collective management organization that can really help to collect royalties for other artistry? Because in music and then movie, we have them. But what about the artisans, those who draw, those who are into those aspects of the creative art, not basically music and then movie, but other artisans? Can you suggest another CMOs that will be available to collect royalties for such people? And if it is, you are able to find out or fish out any collective management organization, how will it be, or how will you propose it to the government? Well, it shouldn't be like Gambro, it shouldn't be like ASOC. Okay. Because with the issue of Gambro and ASOC, I beg to differ. They are not seeing anything at all. Okay. Sure.
Thank you very much. Right, so let me pick it from here. Collective management organization in Ghana here, we have 3 types of collective management organizations. Those responsible for music alone, it is the Ghana Music Rights Organization, for short we call it Gambro. Those responsible for pictures, images, books, drawings, paintings, artworks, sculptures, images in that form, we call it Reprographic Society of Ghana. Reprographic Society of Ghana, for short, Copy Ghana. they are responsible for paying royalties. But let me issue a caveat here that if you are not a member, please don't bother yourself suing them, because you have not given them the license or the mandate to go and collect royalties on your behalf. But if you are a member, then you can collect, they can collect royalties for you. Then the Audiovisual Society of Ghana, which is ASOG, they are responsible for movie and film. So these are the three collective management organizations. What we have here in Ghana, which is these three, are the people who collect royalties. But if you are not a member of them, and if you don't produce content for specific of these royalties, then you have no business with them. Now, I will also want to answer my brother Derek Mani about recommendation to the government, and I want to thank him for asking about that. I want to recommend to government that all the collective management organizations in Ghana need a modern means of collection and payment of royalties. Because what they've been using to pay us is a cake. It is a cake. Why? Because you can't pay me royalties and tell me that you are due this. How did you calculate that this is how much I am supposed to get? So they look at your face. Oh, you are the money everywhere. You go everywhere. So you deserve 5,000. You are, your name is what? Ankama. Nobody knows you. 65 Ghana cedis. You are apostle. Oh, apostle free. Apostle, your song. Oh, apostle has a big church. Okay, let's give him 2,000. That is how I think they are sharing. Because there's no itemized bill to show. Other countries around the world, they will give you itemized bill. Your songs got 170-minute airplay for this month. And so, by the calculation, 1 minute is $1. So $160. Then you are okay. You understand, because they will tell you, all the members within the collective management organization or society, we have 1,000 members. And these 1,000 members, only 75 people's songs were played. And these 75 people's songs amounted to 1,200 minutes. And so therefore, let's divide one per the number of people whose songs actually was played. Not that they collect the money and then they look at your faces and come out with 200. Somebody called me, a very big musician. He called me in Ghana and he said, Bnoskka, I have sent you a message, check and see. When I checked, it was a mobile money alert. He has copied it and forwarded it to my WhatsApp. I checked. For the whole year, he was paid 165 Ghana cedis. And he was very angry. I said, the anger will not solve the problem. Let's go to court. You see, we have to try the law. The reason why I always insist let's go into court is that the royalties that we are enjoying today, in 1847, the first copyright law which was passed to be able to ensure that musicians get royalties was 4 musicians who went into a cafe to go and eat. It is called Café Ambassadorial Paris in French or in France. They went there and then they sat down. They buy 1 or 2 beers, they drank it, and then that hotel owner, that restaurant, they have a policy. You sit down and eat your food. You have kept long, 1 hour or 30 minutes, then you finish, then you go home. But if you sit for so long, 3 hours, 4 hours, you have to pay for the seat you sat on. Because other people would want to come in, right? And that is what is done almost everywhere. You sit down, you stay too long, you say, oh, please, can you, so that somebody can also come and sit down and eat, right? Then, after they sat so long, 4 hours, eating and drinking with their friends, and then the hotel, the restaurant brought them a bill. This bill is for the food and the drinks you ate. This bill here is for the sitting. You sat down. They said, why should we pay? At that time, There was nothing like royalties anywhere in the world. And so they said that, look, if this our music was a land, listen to the argument. If this our music was a land that you have been playing here, you'll be paying us royalties for using our land. So we will not even pay for the food. Why should we pay for the seat we sat on? And the restaurant owner was saying that you sat for too long. It's okay, then let's go to court. They went to court. And the argument they put up, the law court said that, look, the restaurant, everybody knows that this restaurant is very good because they play good music. And the music you are playing, somebody composed it. And that person who composed it is not getting any money. And you are using it to sell your food. And so therefore pay them royalties. And that was the beginning of royalties in the whole world. In France. Because musician refused to pay for his seat he sat on and demanded royalties for his songs being used. We all know the royalty systems in Ghana about land. If a king gives you a land, every year you have to go and pay royalties to him. And that is how music should also look. Even if you put your music free in the societies and people are paying it on radio, they are supposed to pay royalties for you. And another time we'll talk about digital systems, the digital streaming platforms. Even if you are put there for free and they are still playing, they should pay you neighboring rights. Because by Copyright Act, mechanical right is for you. Neighboring right is for you. Performance right is for you. Even broadcasting of your songs on television, you can decide that TV stations should not play your songs. And they have to agree. Even if they have gone to internet to download the song. If the moment you say they should not play, you see, musicians, we are very powerful. We can decide to ban all radio stations in Ghana that do not play our music because we are not paying royalties and demonstrate. Government will listen and they will have to stop. You see, so that is that. Thank you, Derek Money. So I recommend to the government of Ghana and to anybody who is listening to me, both in the ministry and the Ghana Tourism Authority, who gave me this room on a discount, I want to thank them, that we should all help to be able to implement a modern system of collecting royalties and a modern system of paying royalties. Thank you. Any other question?
I've written down 2 questions. So the first one is, so how do I license my music for use in films, TV shows, or commercials?
That's one.
The other one is, what are the current trends and challenges in music copyright laws? Thank you very much.
Thank you very much. Music for films and televisions and all that is basically through blocks in industry practices. You see, it is very difficult for you to walk up to somebody who is making a film that, oh, my name is Bnoskka, I'm a musician, I am Frankie, I make music, so please, I want to infuse. No, we create blocks. You know somebody, somebody knows somebody. And so you set up an agreement, we call a contract. And under contract, you have to now pitch your idea that, oh, if you use my movie for this, I will take this, I will take that, and I will also make sure I will promote your movie in my also music videos. So that you get money, I also get money. And so, therefore, under the Copyright Act, there is no mention of how to pitch your songs for films. But it talks about if a song is synchronized in a film, you must get money. And these are industry practices that we use our plugs, our links, our connections to create those avenues. And that is what we do. Secondly, on your other question of how, help me again. On the collective management organization. The current challenges with music and copyright law is the use of artificial intelligence. The use of artificial intelligence. Please press the green button for me. Press the yellow. Press the red one. This is artificial intelligence making this song. It can sing for you if you give it the words and you give it the melody. It will sing beautiful where your voice will have no problem. People wouldn't know that your voice is not good. So the challenge is that, do artificial intelligence, AI machines and tools and apps, do they owe copyright in the works they create with your help or not? Now, the whole world, there had been 2 decided cases, one in South Africa and one in China. And all other places that decided, China, Australia, and US, they said AI tools don't have copyright ownership. AI tools. So it is the human being who asks the system to create. He owns the right. But then there was a court in South Africa that says that AIs should owe copyright. And we are yet to see how it will be able to be enforced. Because AI is not a human being to go to police station or to go to court to present evidence. And these are the challenges. And the challenges is also that third application softwares, for example, Adobe Studio, Sound Studio, Finale, and then what they call a Qubit, Capella, Fruity Loops, Zion Gate, Q Maker, Quetus. All these applications, they have a long list of terms and conditions that when you are installing them on your phone or your computer or your laptop, you need to take time to read. Sometimes it goes as far as 120 pages, sometimes 200 pages. The least you might find is about 47 pages. You have to read. And somewhere within it, it is said that third parties applications have right over the things you use in making. So when you upload your songs on YouTube and you use a reggae beat, the reggae format you have played, part of it is going to reggae, to Jamaica, as their royalties to them. You use hip-hop, some hip-hop beats, loops, which have already been created on the apps. The moment you use it, those apps makers get part of your royalties to them without even you knowing. And the challenge is, how fair is it to you? Some of the challenge is also about the streaming apps. Until recently, Spotify never gives money to anybody in Africa because they did not make it thinking about you. They made it thinking about people in Australia and in Americas and in the Canadas. So the challenge is, how do we also create our own apps that will be able to categorize our songs under high life, Azonto songs, or Adwa songs, or Agbaja songs, or Sode songs, or Apatampa songs, or whatever. These are the challenges. We need to think of how to create things in this way to be able to help us also maximize our economic gains in terms of music streaming on digital platforms. Until we do that, then we are going to rely on the mercies of these digital apps, AudioMax, Boomplay, Apple Music, and the rest. That is the unfortunate. It's a challenge. Any other question? Right.
Focused on music distribution, rights management, and then artist development. So let me give a background on how we started. 5 years ago, I worked for a music company, and then aside that, I would sort of meet with a lot of artists, emerging ones, that needed support with cover art designs, and then their music. But along the way, I realized that from all the artists that I met, I realized that the main challenge that a lot of artists that we're having here was, okay, recording is not a problem because you meet artists and they already have their recording. So I realized that, okay, so it's easy for you to record. But then they'll be like, well, I don't, when you ask them, why don't you do a cover design? Why don't you put this thing out? Then also we have to consider the digital revolution. So now CDs and all the cassettes were out of the market. So now they can record a song and then only give it out to bloggers. So you meet artists and then he's broke, but he's able to record. And then, but how does he make the money back now that it's recorded? So I started thinking about all of this. I'm okay, so now there has to be a platform where this recording can be shared and then they then profit from it. So from where I worked, I realized that we were sort of using the digital platforms, putting music up on the stores. But then most of the artists that I will meet here, when you tell them about that, they will be like, well, in Ghana, if I put my music on iTunes or Boomplay, people won't go and listen. So I want to give it out to the blogs. So the blogs means that they give it out to the guys that own the news blogs, and then they just put the song up for free. So they were virtually sharing the songs for free. And then I said, okay, we have to make a change. And whether you guys accept it or not, this is the future. Either you embrace it now or you suffer the loss. So we started music distribution, set up a platform. So whenever I talk to them, I'll take the song and I say, you know what, you don't have to pay me anything. I'll create the account for you for free, put the song up, and let's see how it goes. So over time, we started connecting with a lot of artists, and then slowly began to pick up. And then when the COVID came, it sort of ignited the whole spark. And then artists didn't have a choice, and then they realized that, hey, now this song that I'm doing, I really need to be making money from it. And so now there's nowhere to go. They say stay in your room. So you can't go out to perform, you can't meet people, you can't do. So now it became obvious that they have to really focus on connecting with their fans digitally, and then ensuring that they make money from this music that they were doing. So through that, a lot of artists jumped on the bandwagon. We were able to register a lot of artists, and then the education began. So now they have accepted to give the music out and then to make it available on the DSPs. Now the next step is, okay, now that you have the songs on the DSPs, what are the other things that come with it? It meant that they are now required to understand what IP means, which is their property, and then the management of that property, which is the sound or the music recording. So over time, we work closely with Bnoskka. We've done a few workshops across the country, and then educating artists that once you record your music, there are several rights that comes with the music in terms of how you can monetize it and all the other things that you can do with that music. So with Uprise Music, artists that register with us, one of the things that we do for them is ownership. We make the artists understand with the song that they have what they own, which is the ownership in terms of publishing rights and also the master rights of the song. And then we go into copyright registrations. So once you record the song, you also have to consider the registration of the song so that you log everything properly. And then we also hit on royalties and monetization, which is registering with the CMO, which he mentioned, Gamro. There are other international ones that are equally effective. Now that Gamro has no license, you can also consider that as well. And then we also help artists in terms of protection of their intellectual property online, which I'll mention in terms of ensuring that they have proper metadata, and then digital fingerprint, and then also working with credible distributors that can ensure that these things are done for them properly. And also I hit on education and advocacy, which is part of what we are doing now, to continue to educate and then advocate for better structures within the industry that we are building. So I'll sum up for today. The time is almost up. So with Uprise Music, if you're an artist and you are here and you've recorded and you are taking interest in the next step for the content, most of us here are with the company himself and a few others in the back. Once you talk to us, we'll take you through the process and ensure that you do right by your music. Thank you so much. My name is Michael Banfu.
All right, thank you.
In charge of our Girl Parade program. So Bountiful Technologies, our main focus is to teach STEM education, educational robotics, being it younger students, adults. We don't just focus on little children, we don't just focus on adults, but we look at children from the ages of 4, where we are able to teach them how to learn IT, robotics, AI, and then we also train them on digital literacy. So this is what we have been doing. We have boot camps for children where we educate them as well. We have the Girl Power STEM workshop where we mentor girls on how to enroll themselves in STEM education or digital, take digital careers or STEM careers. And then also we have our competition, that is, we train children to participate in robotics competition in Ghana and across Ghana, that is Africa, and then the US as well, that is the VEX robotics competition. So this is what we actually do at Bountiful Technologies.